Hi everyone, my name's Stuart Lester. I'm an intellectual property lawyer at Mishcon Employment, and I specialize in all areas of IP with a particular focus on brand protection and brand enforcement. I'm also part of the Mishcon Sports Group. I'm going to speak to you today about brand protection in sport, and in particular, I'll be looking at the area of trademarks. I plan to cover three areas today. I'm going to give you an overview of IP in sport, and discuss some of the key IP rights. I'm then going to take a closer look at trademarks in particular. And then finally, I'll look at some recent examples of disputes relating to some sporting trademarks. So, as we all know, sport is more than just a game. It's also big business. So whether you're a sport club, an athlete, or a sporting body, a big part of your revenue is likely to derive from activities such as merchandising, licensing, and sponsorship, and all of which involve the exploitation of various intellectual property rights. So what IP rights are we talking about here? Well, there are a whole host of different intellectual property rights, but the main ones include patents, trademarks, design rights, and copyright. So if we look at a Formula One car, for example, it's a really good way of demonstrating a number of IP rights that are in play at the same time. So there might be patents involved. There might be something new and inventive about the technology, about how the vehicle generates speed, for example, and that might be capable of being patented. Now, over the years, sport has been a sector that's really benefited from the patent system. Sporting equipment, for example, is continuously evolving. You've got new technologies that help athletes jump higher, swim faster, cycle longer, and hit the ball further, for example. This is all because of technology, and safety also improves with various technology that is created. And the patent system incentivizes people to innovate and create those inventions and provides a stable platform to distribute the inventions and make them widely available on the marketplace. Going back to our F1 car, there might also be designs there. A design right protects the appearance of a product. So an F1 team might produce a new design for a car that they want to prevent another team from copying. And that might be the appearance of the vehicle, might be the physical shape of the vehicle, might be its configuration, or how different parts of the design are arranged together. And it could even be its decoration. There are a number of examples of designs in sport. For example, the designs of bicycles, the design of sporting footwear. I mean, just think about all the various football boots designs that have come out over the years, or something unique like the Nike Air Jordans when they first came out. They're all new designs. There's very likely also to be copyright involved in an F1 vehicle. Copyright protects original literary, dramatic, musical, and artistic works. So in the case of the F1 car, no doubt there are lots of sketches that have been done, drawing designs for the vehicle, CAD drawings relating to the vehicle, and its inner components or improvements that need to be made. All of these works are potentially capable of being protected by copyright. And copyright also plays a really critical role in sport. I mean, just look at all the promotional and marketing content that you've ever seen for a sporting event, or the designs of logos for the sports teams and for the competitions and tournaments. Even the merchandise that's involved in all of these things, or even software for computer sport games. These are all things that are potentially capable of copyright protection. And finally, there's trademarks. So trademark is a badge of origin. And on all F1 vehicles, you'll certainly see a plethora of trademarks relating to the name of the manufacturer of the car company, or all their sponsors, and all their logos will be on the vehicles. And it's this area of trademarks that I want to discuss in a bit more detail with you today. So as mentioned, a trademark is a sign that can distinguish your goods and services from those of your competitors. And you may refer to your trademark as your brand, and often people use these words interchangeably. Registration of a trademark is not necessary, it's voluntary, but it's certainly advisable, because a registration gives you a valuable commercial asset, a commercially exploitable asset. It's relatively easy to protect and enforce. It's a deterrent to infringers, and it's renewable indefinitely. As long as you keep renewing it, you'll have the registration. So the names of clubs, the names of franchises, all their logos, all of these things are capable of being registered as trademarks. And a brand is a really essential asset and revenue producer for sports teams and their clubs. From a consumer perspective, the brand is critical. Brands are indicative of quality and brand loyalty. They generate the allegiance amongst the fans and drive sales of products and merchandise with those trademarks on the goods. So there's also trademarks for all the leagues and the sporting bodies hosting tournaments and championships. I mean, such as Wimbledon and the World Cup and the Olympics, they've all got their own trademark registrations for their brands. And individual athletes too. So many athletes who become the dominant player in their team or in their sport will develop their own individual brand, and they'll go on to register those as trademarks. There's numerous examples of athletes who raise their teams and entire leagues to national or even global stardom and strengthen the brand and goodwill associated with their name and with their team or tournament that they're involved in. Look at examples of Ronaldo or Michael Jordan or Serena Williams, who've made a major impact in their sports. And this in turn creates business opportunities for related sports industries, including goods manufacturers, apparel, shoes. So there's a bit of a domino effect there. And celebrities also capitalize on their own branding power and drive goodwill in sporting goods and sportswear by registering trademarks relating to their own product lines. So we've had celebrity athletes like Roger Federer, or Tiger Woods, or more recently Jesse Lingard, who have created their own brands and their own lines of clothing, and they've gone on to have really good success doing that. So now we've got a basic understanding of the interplay between the different IP rights in sport. We've also had a closer look at trademarks and the significance of trademarks. In the last part of today's session, I want to take you through a few examples of cases in recent times that's involved sporting brands. First up, I want to talk about the Massey dispute. So, as well as beating the record for all-time most goals scored for a single club this year, I'm sure Messi, the 6-time Ballon d'Or winner, was equally as happy to have won a legal battle this year involving his trademark, which allowed him to register his surname as an EU trademark. So the background to this is that in 2011, Messi applied for an EU trademark covering a range of goods and services, but most importantly for clothing and sport equipment. This mark was opposed by a Spanish cycling company with earlier rights in the word mark Massey in the same classes of goods and services. So we've got Messi versus Massey. So the EU Intellectual Property Office upheld the opposition against Messi's initial appeal against a decision that dismissed his case on the basis that the registration of Messi would lead to a likelihood of confusion when compared to the earlier mark Massey, given the very close similarity between the two marks and the identical nature of the goods and services. Messi then appealed to the General Court. This is a court you go to appeal decisions of the EU Intellectual Property Office, and they reversed the decision. It then went for a further round of appeals to the CJEU, that's the Court of Justice of the EU, and they're able to take appeals from the General Court. And they confirmed the General Court's ruling, which allowed Messi to register his trademark. So what they held was that even though there are strong visual and phonetic similarities between Messi and Massey, these were outweighed ultimately by the conceptual differences between the marks and the widely accepted reputation of Messi. So in reaching their decision, they said that the reputation of Messi as a world-famous footballer constituted a matter of common knowledge, which did not need to be substantiated by any evidence, and that any small proportion of the relevant public that would not associate Messi with who he is, the world-class football player, was considered to be insufficient to give rise to a likelihood of confusion. So here we've got a case where the immense reputation of a footballer was sufficient to create a conceptual difference between two marks that are very, very similar, Messi and Massey. It'll be interesting to see how this case is applied. It was hard fought many, many years. And Messi is arguably the most famous footballer in the world, one of the most famous footballers in the world. And so it'll be interesting to see where that threshold of fame lies. Would the same decision be reached to somebody who was slightly less famous? Unfortunately, the judgment didn't give us any kind of guidance in respect of assessing fame, but it'll be interesting to see how it's applied in the future. So next up, we're going to stay in the world of football, and we're going to talk about a case involving Wolverhampton Wanderers Football Club. So this is actually a copyright case. It relates to a fan's claim that he designed the logo that's used by Wolverhampton Wanderers. So Mr. Peter Davis brought proceedings against Wolves, alleging copyright infringement in the wolf head design, which he said the club adopted in 1979. His claim was that he created the logo in the 1960s and had entered it into an art competition at school at the time. And he said that his drawing and the logo was so remarkably similar that they must have been copied. It must have been taken from that competition and used. His explanation for why it took him almost 40 years to bring the action was that he had only recently come across the drawings when clearing out his loft. So although he initially survived a summary judgment application against this claim, his claim was eventually thrown out because he was not able to show that Wolves had ever seen his logo. Although the judge said that there were noticeable similarities between the works, there was really no evidence that anybody at Wolves had ever seen this piece of art. So I guess this case serves as a reminder that to prove something like copyright infringement, you have to show that the evidence points to a direct link of copying the work, and mere similarity is not going to be enough. Next, I'm going to turn to an individual footballer by the name of Neymar. So this is an example that with fame comes the consequences of bad faith filings and squatters. These are people who, third parties who seek to register trademarks in bad faith, with improper motives to try and make a quick buck. This case relates to an application for the word Neymar for clothing goods. And this was filed by a Portuguese individual called Mr. Carlos Moreira in 2012. So in 2012, Mr. Moreira had the foresight to register the trademark for Neymar before Neymar did. Neymar didn't notice the application at first, and so didn't oppose the application. And then he realized its existence in 2016, and he filed an application to cancel this trademark in 2016 on the grounds that it was clearly filed in bad faith, purely to take advantage of Neymar's name. Mr. Moreira said that that was not true, that Neymar was not well known in 2012, and he forced Neymar to provide evidence of his fame in 2012. Unfortunately for Mr. Moreira, he also filed another trademark around the same time for Iker Casillas, which was a former Real Madrid goalkeeper. And so it was quite evident on the facts that he'd been registering names of third-party athletes. And so his claims really didn't hold much water. Bad faith is generally quite difficult to argue, but Neymar's lawyers went to the extent of providing the evidence showing that Neymar was very well known in 2012, still very well known in the EU. And then along with showing that this individual had also filed trademarks for other athletes' names, presented a strong argument that there was bad faith involved here. So relatively straightforward and a decision you'd probably expect, but it does highlight how prevention is better than cure in trademark cases. So many countries operate a first to file system for trademarks. And that can make life very difficult for brand owners if third parties file their applications for their brand names before the brands do. So the lesson is brand owners should always be one step ahead and seek to protect their important brand names in countries that they may have an interest in, even if not currently, if they think they may do in the future. It's good to get in there first. Obviously, that's not so easy for individuals like Neymar, who perhaps can't foresee their success in the future and what countries they'll be successful, but it's certainly something that brand owners should be aware of. The final case I want to look at is involves Liverpool. So sometimes a major brand, when they're filing trademarks, can take it a little too far, and this might be a case where Liverpool did that. Liverpool Football Club applied to register the word Liverpool on its own for a whole host of goods and services. So i.e. Liverpool without football club at the end. And those goods and services included things like clothing, but also more random goods like games, telecommunications, stationery, office equipment, in addition to actual sporting goods and services. They said they did file this application on such broad terms for Liverpool because they wanted to have a trademark that would protect them for all these goods and services and for all kinds of counterfeit goods as well, that they could use to enforce against these counterfeit goods. This is actually something that a couple of other clubs have done successfully. Chelsea Football Club and Tottenham Hotspurs have succeeded in registering trademarks just for Chelsea and Tottenham. However, in Liverpool FC's case, this was met with a lot of vocal opposition against their application, including the mayor of Liverpool, who expressed outrage, including in one tweet where he said, "I've informed Liverpool Football Club that I and Liverpool Council will oppose their attempt to trademark the name Liverpool. I do not believe you can trademark a city name. I value our relationship with Liverpool Football Club and will work to help remove counterfeit goods, but we will also protect local traders and our brand." The UK Intellectual Property Office eventually rejected the application on the ground that the word Liverpool had such geographical significance that Liverpool FC could not effectively monopolise the word for all the goods and services that they were looking to register the mark for. Liverpool FC then tried to avoid this by filing a divisional application for just some of the goods and services, but by this point, the negative PR had already kicked in, and following 54 notices of threatened opposition against their application, they decided it was time to just withdraw the application. That brings to an end this talk on brands in sport. I hope you've enjoyed hearing about the various IP rights and the recent disputes that have involved sporting trademarks. If you have any queries at all, please don't hesitate to get in touch. Thanks for listening.